I apologize, I was running a little bit late, so I'm glad everything kind of is working on time here. Usually for conferences and summits, they run behind, and I was counting on that, so it didn't work out. And Amanda, as Dawn and I were mentioning before, Amanda's everybody's boss. We all know that. So, okay, what we're going to talk about is Civics 101. Go back to freshman year in high school and talk about federalism. Everybody who kind of hears about federalism, whatever spectrum you're on, federalism is a major issue. And because it's discussing the balances of power between our type of government that our founding fathers chose a long, long time ago. So getting into it right off the bat, and also feel free. If you have questions, you want to make a comment, you think I'm absolutely crazy, which I am, feel free to jump in, raise your hand, and I'm sure somebody else either might have the question or definitely would appreciate your perspective on the topic, because obviously it's a very important topic as we're trying to deal with the various levels of government. So federalism, pretty straightforward. Distribution of power in an organization, such as a government, between central authority and the constituent units. Straight out of the dictionary, didn't need to go back to freshman year in high school on that one. Okay. A little bit more larger definition, dealing specifically with the government and the handling of the distribution of power between the government. All right. So specifically, there's a central government. Obviously, for us, Washington, D.C. is the federal government. At the founding, if you agree with me or disagree, whether you're a federalist or an anti-federalist, the central government was obviously meant to be weak, have very few responsibilities, and because they were only given what's called delineated powers, the states had to carve out, which is everything else is ours. If it's not in the Constitution, it's ours. You can't take it from us. That's how the Constitution was initially drafted. Obviously, because a bunch of lawyers wrote it, it kind of has morphed over time to a different balancing, especially with some Supreme Court analysis, as well as action that both the states have taken, as well as the central government, to constantly refine that relationship between the levels of government. The participation, though, is expected by the people at every level of government. And that is one of the major issues of federalism, was that there's going to be multiple outlets. There wasn't just going to be one king that you had to present your petition to. You had the ability to present your petition to multiple different sovereigns to hopefully achieve the goals, not just for you as an individual, but for the greater community. Oh, fast. All right, so here, Constitutional 101. All right, had to take a full year of this. Mitch probably did it in 15 minutes. Okay, just want to make sure. So these are the key legal authorities within the Constitution for which our federalism is based. Everybody always hears about Article 1, 2, and 3. Article 1, legislature. Article 2, executive. Article 3, very small, talks about the judiciary. Sometimes it's get flipped around as to emphasis of power, but that is not the concept of federalism within the unit of government, which is the federal government in that context, as adopted also by the states, right? What we have here is how are we going to relate between states, state to state, as well as the states with the federal government. And all this is going to make sense at the end as to how you can participate in the process. Not that you already don't know how, but a lot of people don't take an opportunity for those advantages. So the first one we always hear about is the supremacy clause. Okay? So if it's in one of those delineated powers, and the federal government takes an action, and the federal government being broad, the executive, the legislature, or the Supreme Court, okay, and it's within one of their delineated powers, then that is supreme. That's preemption. Obviously, many of you are in the energy and the environmental world. Because of some of these other provisions that we're going to talk about, the federal government has moved in and considers in many areas to be preemptive. However, the reason why Congress is able to move in is because of the Commerce Clause. Okay? I'm not going to bore you on the case law. It goes back and forth as to which way the importance of the federal government using the Commerce Clause, and the Commerce Clause being states interacting with each other. So if it goes into the stream of commerce and it's going to cross state lines, then the federal government's able to regulate it. And it's not just commerce, right? Anything that could impact commerce has been read very, very broadly by the Supreme Court. Now, our current court, not to get political on you, may bring it back a little bit. Okay, that's the perspective, especially if there's one or two more justices get on it, get on the court. You'll probably see this get reined back in a little bit. Okay, spending clause. One area of the spending clause that people don't talk about quite often in regard to federalism, because the spending clause is actually a carrot that they use to basically take the rights of the states. Okay, so the more notorious one, age 18, everybody like to have a drink. The federal government said if you want our transportation money, you're going to have to raise the drinking age to 21. South Dakota said no, we'll take your money, we're going to leave the drinking age at age 18. Supreme Court said no, you take the money, you got to move your minimum age for drinking up to age 21. And that's been held over and over and over again. Most recently, or it's not most recently since it was about 10 years ago, it was a case that I actually handled, and I dealt with military recruiters on campus. Okay, so the universities were more than happy to take our money. For Yale, who was the main plaintiff at the time, it was about $100 million in federal funding for research and development. We'll take your money, we don't want your military recruiters. Supreme Court unanimous decision said, if you take their money, you have to come back, the military recruiters come along. So that's alive and well, and the idea is that if you don't want to do it, don't take the money. Okay? The 10th Amendment, this was very important to the Founding Fathers, and that's where I mentioned at the beginning of the presentation, which is whatever's not in the Constitution is ours. You don't get to take it. But of course, what was a little bit of ambiguous at the time was who can sue states, right? And right after the bat, the Bill of Rights are passed, and immediately I think somebody in Boston sued the state of Virginia in the state of Massachusetts. Supreme Court said, yes, that's allowed. You can actually sue Massachusetts in the state, or sue Virginia in the state of Massachusetts. And of course, the states got together real quickly and said, no, that's not going to work out for us. They passed the 11th Amendment. So the states then regained some of their rights on the ability to do it. And then finally, after the Civil War, we had a flurry of different amendments as a condition for the southern states to come back in with the Union, one of them being the 14th Amendment. The 14th Amendment is more driven by individual rights, but it's also about equal protection. And no matter where you are, that you have the equal protection of the laws at every level of government, too. So it gets back into the whole concept of federalism that a lot of people felt was taken away during the Civil War. So it's trying to regain some balance, but at the individual level. So I apologize about the history lesson there, but that's the foundation of how federalism works within our constitutional system. So again, it's a cooperative federalism. And just because the federal government might be using something out of the Constitution, what they appreciate, though, is that the state will have a role, usually in enforcement, or planning, or carrying out the function. And when the state does it, they're not relying on the federal authority to do it. This is very important, what Congress and Supreme Court wants, is that they're using their inherent police power to do it. So not only do we have this federal authority, that Clean Water Act, Clean Air Act, whatever it may be, but in addition to that, the states have an inherent right to protect the health, welfare, and safety of the people. That's a state right, a state requirement. So they're using the federal government to tell us to do something, but then they tack on the state obligations through it. And most often, it's not just, hey, we have the federal law, we're also doing it because of the 10th Amendment. Okay. So participation, all right, at every single level. And this is what, as a lawyer who does a lot of litigation against the government once in a while for them, they pay the right, I'll do it for them, just kidding. But the federal government, the government process, what people come to me all the time, and Don's heard me say this before, is how in the hell did that law become law? We have to do what? It makes absolutely no sense from an operational standpoint. It makes no sense from another practical standpoint. It just doesn't work. The mechanisms do not work, either from the statutory level or from the regulatory level. But at every level of federalism, the government gives an opportunity for the public to make comment. Obviously, in emergency situations, that's not always given immediately, but there's usually a tack on afterward, and there's at least a comment period, etc. And what we've seen is courts recently say is, say it's a company who does not like a regulation, or even an individual who does not have the regulation, but they're traditionally in the space, and they don't comment on it. That's actually been used as a factor against the company, saying you allowed this to go through 10 years of study, through all of the regulatory and statutory process, and you never objected to anything that the government was planning on doing. And then right during the application process, you bring a lawsuit. So what these next few slides are showing is all the opportunities to get involved in the federalism type process at every single level. Because remember, for the federal rulemaking process, it's very similar to Arizona, so that's what we're going to cover here, is you need statutory authority. An agency is not supposed to just go act without some sort of statutory authority. Now, that also goes for, so if it's a federal requirement, okay, because of our system of government, federalist government cannot tell a state agency necessarily what to specifically do. Now, the agency may interpret the laws and try to carry them out the best as possible, but those also need to be implemented at the state level. So the carry on, if I'm carrying out a federal government function, there needs to be some sort of hook to that state agency to be able to do it, either an authority from it. Here are the challenges. Before, for this in the federal side, before it can be actually put into place, you have to find a rule, etc. It does have to go to congressional review. Okay? And it's usually, unless Congress acts, it will go into effect. But no one takes advantage of that. No one is driving some of the delegations to say this is really going to have a negative impact on Arizona. So that's one level that can be inputted right there, is getting the congressional delegations on. After that, you obviously have the right to challenge the statute. The challenge of statute, again, is outside the federalism system. That's something that's more in the rights of the state, or it's outside of the Constitution and with delineated obligations there. Okay? Once the statutes are passed and maybe still in debate, there's going to be the regulatory process. That will go a long ways. But one thing that you have to do, you have to keep in mind, is that there's a procedure for everything. And that goes back to the 14th Amendment on due process and equal opportunity. And through that process, they have to treat everybody fairly and equally. So as part of that, there's the Administrative Procedures Act that says that you're not implementing the regulations correctly. I'm not passing judgment on what you want to do, but you're not doing it right. And a lot of people skip that step. They're just like, I don't like what you're doing. You have to think about the procedure itself, and then if that's possible, to challenge it. Then, of course, once it comes out, did they violate this, the Constitution? Did they violate the statute? Did they go beyond their authority? Is this within something that's within their prerogative? And then once there's actually an action itself, that is when you're going to be challenging the executive. So Arizona's a little bit different. I don't know if you all remember this one. 2014, it's a federalism initiative that was passed in the state. And basically it came to is that if the Arizona state government felt like the U.S. government was violating the Constitution without taking them to court, then technically, and there was it would be interesting how this would actually work in practice, but the concept being is that if the government, whether the legislature or the governor, felt that it was unconstitutional to take some act, then state resources would not have to be used. Now, obviously, this is fraught with a whole bunch of issues, going back to the first slide of the spending clause and the commerce clause and things of that nature. But it does show you the steps that states will take to regain the balance on the federalism. Has not been litigated, has not been used, but it has a lot of language in there to the extent that people aren't using it well. Okay, key points, obviously understand the federalism process. It is shocking when we do meet with general counsels and they say, tell me how this law was passed. The process of being in the regulatory environment, and interacting and having trade groups, etc., we shouldn't be surprised when things actually land and become law or become regulation. There's multiple notices at every level. And sometimes I just have to shrug. It's like, I don't know how it got passed, but there's opportunities for it. Obviously, participating at every level of government. And what we see here more often than not, when we advise to say, participate in this process, I don't want to get involved, it's going to be too costly, or I don't need the negativity. I don't need the bad press. That's what we hear more often. So using exactly what you were talking about, using the trade groups, using the chamber, things of that nature to be part of the process is important, because even though it might not go across the media in a good fashion, at least that point of view was brought forward and put as part of the record and considered by the stakeholders. Now, a lot of people think, this is what I have lobbyists for, who are meeting with the key personnel, the executive, and meeting with the legislature to frame these statutes and these regulations before they get out. And that's great. I highly encourage that interaction and process. The problem is that's not put down in writing, right? So if I'm a judge later on, I have absolutely no idea what the Rock Association explained to legislator A. But if it's inside the record, I can point to it specifically and then say, Judge, I was right. Look exactly what the association said. The other issue is, this is more on the agencies. And the agencies rightfully hate this. But it's the public records request. And I say rightfully because it is a huge burden on the agencies. But it's a very important step in our federalism process to be able to ask that information and understand, not from the public view, what was going on in the committees, etc., that the regulation got passed, what was happening behind the scenes. How did you come up with the initial rule that was eventually turned into the final rule? Because that's very important. Now you might know and understand their rationale and say, well, that actually makes sense. They were relying on this study, etc. So public records request, again, rarely used for regulatory process, I think is an underutilized tool. It's used for a lot of other reasons. And then congressional inquiries. At any point where you think an agency is acting above and beyond what they're allowed to do, the Congress, and when I was in the military, we used this all the time, was congressional inquiries to get the congressional office interested in our issue, number one, and usually they're just asking a simple question. Why was this done? And then more often than not, they're going to respond to the Congress and senators. Okay, so I know that was a data dump on federalism, a 30-minute overview. It's my own TED. That's what I call it. But I'm happy to take any questions about the regulatory process and the concept of federalism. Yes, sir.
Two questions. One is, if under the 11th Amendment, the federal government cannot sue states, why does it do it all the time?
No, the federal government can. So you, in Arizona, right, you could not come and try to sue New Mexico in Arizona. Right. Because Arizona has not, or New Mexico has not raised its sovereign immunity. And that's where the crux was. And it was, I don't remember the case in particular, but that's what happened. So the federal government, though, they can sue you. DC Circuit, whoever has jurisdiction. Yeah, DC Circuit, and of course they get a forum shop, especially if it crosses state lines. So for example, because the interstate commerce, it's starting, although Arizona might be impacted, I'm going to sue possibly Arizona and California in California to get a better jury pool or bench, quite honestly, to address certain issues. But on the flip side, they might pick Arizona for other reasons.
One other question on this.
Yes, sir.
It seems to me that the legislative branch is tasked with making laws, and writing rules is essentially making laws.
Correct.
Why can't it be delegated to the executive branch?
So it's the carrying out function, so it's the executive function. Now you're going into the constitutional aspects between the deviation of the branches. So the agency has to carry out that law, basically, to get their marching orders on a broad level from Congress, And then over the 200 years, they've come up with this regulatory concept, which has been codified, right? So Congress has allowed them to do it, right? And this is where we get into, is the congressional review process, right? So if Congress, this has just recently been strengthened, which allows Congress to go in and basically line item's a bad word, but you know what I mean, take out some regulations that they find troubling over on a passage. But this is during the regulatory passage process, the review process, and Congress allows the agencies to do it, but then it's an up and down, or it's actually down if you don't like it.
So it's essentially delegating their constitutional authority.
Well, through a statute, right? Because so most statutes are written or creating, so like, I think I turned this off. So creating the laws, Clean Water Act and things that EPA is creating, for example. The EPA is created to carry out this function. Underneath those laws, there were I'm getting way out of my area, so I apologize, Mitch. But there's state functions and there's federal functions, and that's all through the statute. So the statute then gives them the authority. The regulators then take that authority to create the regulations to carry out the direction of Congress. Yes, sir.
Where we run into problems, though, where Congress passes a law like the Clean Water Act that says it has to be fishable and swimmable by 1990 or something like that, which is, certainly open opportunity for EPA to do what they do. And so if Congress doesn't detail it, then we're stuck with trying to limit the impact of those regulations that are passed by EPA and various state agencies. That's a problem.
Right. So you're saying limit the impact, right? And I know for the waters, what are interstate travelable waters, that was a huge issue in the environmental world, again, which I'm getting out of my realm. But a big issue at the regulatory stage before this was, so Congress passed that. Then the agency had to come up with definitions. And what was, I don't want to say missed, because I think industry was heavily involved in trying to steer the EPA to the right decisions on that, is the agency then came up, it was the Corps too, came up with definitions. But at least they put that out as to what does this actually mean. And then obviously, if you think that they went beyond what the Congress allowed, or Congress wasn't within one of their delineated powers, you obviously have the right to sue them. And they got, not only did they exceed their constitutional authority, and their definitions were all wrong. But I'm with you. Yes, sir.
Going back to your South Dakota example.
Yeah.
So if South Dakota wanted to stick to keeping the age at 18, do they have any kind of mechanism that they could use to withhold the federal funds?
Yes. So you would
federal funds back, like keeping the federal funds in the state and using them?
Right. So usually that's triggered by the secretary. So in that case, it was the Secretary of Transportation who made a determination as to whether or not South Dakota had passed the law to an adequate level to what Congress wanted. And if you didn't pass the law, the secretary then just would not authorize the funding, the transfer of the money to South Dakota.
I'm talking about South Dakota keeping federal funds. Is there any way they can keep funds that normally would go to the feds and use it for something?
Good question, and there's not, because of not an easy one because of the taxation model.
California is trying to do it.
That's right.
Now, correct?
That's right. And it's been tried over and over and over again. It just never really gets out of the state level. But good question. That'd be interesting.
I think I have time for one more. Does somebody else have a question?
Good question.
Yes, one more. I know this is outside your scope, but when the Supreme Court makes a decision,
Yep.
and it's kind of final decision, it's then treated as law, but they're not the lawmaking body. Why is that?
So it gets rebanded. So the opinion comes back down, and then you actually have an order all the way back down to the district court level. The district court level will issue an order carrying out whatever the requirement is. Okay. Sometimes it's another good point though. Is so you don't like the Supreme Court opinion. Sometimes there's a way at the district court level to frame it how that order is going to be written, because that order is what you actually have to do. You have to follow the district court. But then both parties might say, that's not what the judge, you got it wrong again. That's not what the Supreme Court said. it said X. So it's not the Supreme Court immediately telling Brett to do something. It comes back down to the district court level.
But it doesn't get remanded back to the legislature to fix the law.
In many cases, it never gets remanded. What they say is, we'll give you another opportunity to fix it, but until then, your law is stayed. So in our state, you saw that with education funding for about 12 years. They constantly kicked the can down, giving the legislature every opportunity to fix it in the mind of a judge without knowing what the judge